Section 7. When accused lawfully arrested without warrant. When a person is lawfully arrested without a warrant involving an offense which requires a preliminary investigation, the complaint or information shall be filed a prosecutor without need of such investigation. An inquest has been conducted in the existing rules. In the absence or availability of an inquest prosecutor, the complaint may be filed by the offended party or a peace officer directly with the proper court on the basis of the affidavit or the offended party or arresting officer or person. Before the complaint or information is filed, the person arrested may ask for a preliminary investigation. In accordance with this rule, but he must sign a waiver of the provision of Article 1 to 5 of the revised Penal Code as amended in this presence of his counsel. Notwithstanding the waiver, he may apply for bail. The investigation must be terminated within 15 days from its inception. After the filing of the complaint or information in court without a preliminary investigation, the accused may within 5 days from the time he learns its filing ask for a preliminary investigation with the same right to adduce evidence his defense as provided in this rule. Section 8. Section 8. Records. A. Records supporting the information or complaint. An information or complaint filed in court shall be supported by the affidavits and counter affidavits of the parties under witnesses to together with the supporting evidence and the resolution of the case. D. Record of preliminary investigation. The record of the preliminary investigation, whether conducted by a judge or a prosecutor, shall not form part of the record of the case. However, the court on own initiative or on motion by of a party may order a production of the record or any of its part when necessary in the resolution of the case of any incidents therein, or when it is to be produced as an evidence in the case by the requesting party. Section 9. Cases not requiring a preliminary investigation nor covered by the rule on summary procedure. A. If filed with the prosecutor. If the complaint is filed directly with the prosecutor involving an offense punishable by the imprisonment of less than 4 years, 2 months, and 1 day, the procedure outlined in Section 3A of this rule shall be observed. The prosecutor shall act on the complaint based on the affidavit and other supporting documents submitted by the complainant within 10 days from its filing. B. If filed with the municipal trial court, if the complaint or information is filed with the municipal trial court or municipal circuit trial court for an offense covered by this section, the procedure in Section 3A of this rule shall be observed. If within 10 days after the filing of the complaint or information, the judge finds no probable cause after personally evaluating the evidence or after personally examining in writing and under oath under oath the complainant and its witnesses in the form of searching questions and answers, he shall dismiss the same. He may, however, require the submission of additional evidence within 10 days from notice to determine further the existence of probable cause. If the judge still finds no probable cause, despite the additional evidence, he shall, within 10 days from its submission or expiration of said period, dismiss the case. When he finds probable cause, he shall issue a warrant of arrest or a commitment order if the accused has already been arrested and hold him for trial. However, if the judge satisfied that there is no necessity for placing the accused under custody, he may issue summons instead of warrant of arrest.